Ready, start. In the judgment of the case Moin Akhtar Qureshi versus Central Bureau of Investigation CBI delivered on December 24, 2025 at the Delhi High Court, Justice Nina Bansal Krishna has made it clear that the magistrate power to order sampling is necessary for the purpose of investigation. The investigating agency has the prerogative to scientifically verify if the voice in the material available with them matches with that of the practitioner para. This petition was filed under Section 482 of the Code of Criminal Procedure CRPC 1973 for quashing and setting aside of the impugned order dated October 26, 2021, passed by the Special Judge PC Act CBI, whereby the petitioner was provided to direct his voice samples for verification and comparison with certain intercepted telephonic conversations. It was alleged that between the period from December 23, 2022 and October 6, 2014, the Income Tax Department intercepted telephonic conversations of the two mobile numbers allegedly belonging to the petitioner para. On February 15, 2014, the Income Tax Department conducted searches at the premises of the petitioner. Subsequently, the Directorate of Enforcement ED filed a complaint with the CBI on August 31, 2016, requesting the registering of a FIR based on the said intercepted telephonic recordings and BlackBerry Messenger BBM messages alleging that the petitioner was acting as a middleman for certain public servants para. Consequently, the CBI registered this FIR on February 16, 2017 under Section 120 BIPC, read with Sections 8, 9 and 13 subsection 2, read with Section 13 subsection 1D of the Prevention of Corruption Act 1988 para. The petitioner joined the investigation and appeared before the CBI on multiple occasions in 2018. In March 2021, the CBI filed an application before the special judge seeking direction for the petitioner to give voice samples for comparison by the Central Forensic Science Laboratory with the intercepted calls obtained from the Income Tax Department. The special judge passed the impugned order on October 26, 2021 and allowed the application relying primarily on the judgment of the case of Ritesh Sinha versus State of Uttar Pradesh 2019 8 SCC 1 para. At the outset, it is pertinent to observe that procedure is the handmaid and not the mistress of justice and cannot be permitted to thwart the facts finding force in litigation, as was observed in the case of Vatal Nagaraj versus R. Dayananda Sagar, AIR 1975, SC 349, para. Justice V.R. Krishna Iyer in the case of Sushil Kumar Sen versus State of Bihar 1975, SCC 74 succinctly noted that the morality of justice at the hand of law troubles the judge's conscience and points an angry interrogation at the law reformer. The procedural law so dominates in certain systems as to overpower substantive rights and substantial justice para. The humanist rule that procedure should be the handmaid, not the mistress of legal justice, compels consideration of vesting a residuary power in judges to act ex debitio justiciable, where the tragic sequel otherwise would be wholly inequitable para. Justice Iyer has stated further that I must sound a pessimistic note that it is too prudential for a legal system to sacrifice the end product of equity and good conscience at the altar of procedural punctualization, and it is not too radical to avert a breakdown of obvious justice by bending sharply, if need be, the prescriptions of procedure. The wages of procedural sin should never be the death of rights para. Therefore, it needs no reiteration that procedural laws cannot be overemphasized to defeat the substantive justice, as they are intended only as a path to reach the justice and not the result itself para. Justice K.C. Dasgupta, in a concurring opinion in the case of Kathi Kalu, observed that Article 20, subsection 3 of the Constitution of India says that a person shall not be compelled to be a witness against himself. The question which arises is an accused person furnishing evidence against himself when he gives specimen handwriting or impressions of his fingers, palm, or foot. The answer to this must be in the negative.